morning and to another episode of Saturday Morning with Sam. I am Sam Gaylord, managing partner at Gaylord Pop and disability litigator in the state of New Jersey, representing injured workers in the areas of workers' compensation, Social Security, disability, and disability pension appeals. And I want to say good morning and welcome to everyone who is watching. And I want to say thank you. We had a great past week. And I got a lot of nice comments on the fact that the topic of today's conversation. So I'm looking forward to tackling that with everyone. But I wanted to say thank you, and I appreciate everybody joining me, sharing this information with as many people as you are, and celebrating with me the success that we are, I think, achieving by providing not only the right information for people, but also the access to being able to ask the right questions. So I want to say thank you. I look forward to this every week, and I am looking forward to diving in today and talking about what we're going to discuss. So last week we had a preliminary discussion on the Social Security process, and what I wanted to do was sort of take a deep dive into the Social Security process, how to apply, and more importantly, what to expect when you are getting ready to have your day in front of the administrative law judge. So basically, the way that Social Security disability operates is that if somebody is out of work for at least 6 months and has documentation either by way of their doctors or just their own employment or post-employment in terms of being not able to return to work for at least 1 year, then you are eligible to apply for Social Security disability benefits. Now, the key is to get this process started as soon as you can, because potentially Social Security disability, depending on your particular disability, but Social Security disability can prevent, or I should say, hey, good morning, Christina. The Social Security disability application process can take almost up to 2 years to get through. And that is right now, to me, a ridiculous, morning, Mario, a ridiculous extension of time. So one of the things that I strongly suggest to clients is that they initiate the process as soon as possible. And the way in which that can get accomplished is that you can either, hey, Loretta, good morning. You can either apply online, or you can go to the local office, or there's an 800 number that you can call that would allow you to initiate the application process. The most important thing that I can tell people is that when you're starting the process of the application, you want to make sure that you are including all of your medical issues. We tend to focus on, hey, April, we tend to focus on the things that bother us the most, or the things that are the most severe. So I've had let's say a back injury, and I've had back surgery. So that's the thing that gives me the most trouble. However, I also have, I don't know, diabetes, whatever. And so you tend not to focus on the things that aren't necessarily by themselves disabling. But when it comes to Social Security, what I always tell the clients is, if you're seeing a doctor, if you're taking a pill, whatever that condition is, you include it in the mix. Because when it comes down to it, Social Security disability, the more paper that you can provide, the more medical documentation you can provide, the easier it is for someone other than a judge at the end to make a decision that you are in fact disabled. And at the end of the day, that's the most important thing, is that someone who early on in the process, who's sitting in a cube and who has blinders on to what's going on and who's just simply doing what they're told to do, is given enough that they can actually make a decision that's positive for purposes of granting Social Security disability benefits. So just to give you a sense, though, the Social Security process is a 3-step process. You have an initial application. Most people get denied. You then have what's called in New Jersey reconsideration, and not every state has that. Pennsylvania, for example, you go from an initial application right to requesting a hearing. But in New Jersey, there's what's called request for reconsideration, which is a 2nd step. And then if you get denied again, then there's a request for a hearing in front of an administrative law judge, which is the final step in the process. So the real kicker is the length of time that it takes once you're requesting a hearing to actually getting the hearing date. Now, what's best about that is, and what we try and do, is that as time is marching on, we're gathering the medical records. So what will happen is, once we have enough in terms of the medical documentation, what we'll do is send a letter to Social Security asking them to review their claim in advance to potentially avoid the need to have a hearing. Now, sometimes it works, sometimes it doesn't, but Social Security has lawyers who review those requests. Now, we can't make that on every single case, as much as I'd like to, but there are certain cases where, and it's sort of like the cases that you think to yourself, how could this be? How could somebody look at this person and not find them disabled? So that's sort of the key to the equation. Now, once you get, though, into that request for a hearing, and the hearing comes up, Social Security will send a letter about 75 days in advance of the hearing, telling you that you have a hearing that's coming up, telling you that it's where it is and what to expect. Now, there are these days requests that go early to clients or to people who are requesting that the video or that the hearing be done by way of video. I'm going to strongly suggest that if you are out there and you get that you do not, because you can request a live judge, that you request the live judge, that you do not agree to have a hearing by way of video, because you'll get some judge, you can get potentially some judge from Chicago or Boston or New Hampshire I just recently had, and you just don't know, because, we don't appear in front of those people. So there's not a familiarity with the style of the judge such that I can then advise somebody, hey, look, this is what's going on. This is what you need to be concerned with. This is what the judge is going to ask you. And if they're live, then we've appeared in front of them over and over and over again, which then puts us in a position where we can really advise, hey, look, this is what we want to be aware of. This is what's going to happen, those kinds of things. So certainly request the live in front of the judge, okay? Now, when it's time for the hearing, what is going to happen? Well, first things first, a Social Security disability hearing will last about an hour. Sometimes a little longer depending on the judge, but for the most part, it's going to be about an hour. So what typically will happen is that the judges will start the questioning and they will start the process. Now, The questions, I always describe it as being in terms of categories or buckets in terms of what they're going to ask. So they're going to ask about background information. How far in school did you go? Who do you live with? Do you have pets? You drive? Those kinds of biographical, do you have children? Biographical information questions. And then the next set of questions go to what Social Security deems to be past relevant work. So in other words, what have you historically done for the last 15 years? And that's all Social Security cares about, is that window of time of about 15 years before your application. What did you do? So that's past relevant work, which is the second category. Then they're going to ask about your disabilities. What is preventing you from returning not only to your past work, but to do some other job? So they want you to talk about the injuries and your disabilities and list them almost first, and then discuss it from the standpoint of, okay, those are your problems. How do those problems then affect the ability to do work? So the judges usually put them into those categories, and I think they all sort of follow the same script. But for the most part, those are the things that you need to be thinking about. Now, again, I said earlier that you want to make sure you include everything. But if you go to the podiatrist because you have bunions, obviously that's fine that they have those. And yes, they can be painful, but that's not something that's going to prevent you from working. So that's not something that you're going to focus on or talk about really while you're at a Social Security disability hearing. You're going to focus on the things and the disabilities that prevent you from going to work, why you think they prevent you from going to work, and how do they affect you on a daily basis. So that's what's important. And I always tell people what you want to focus on is telling stories. So what I mean by that is, in my opinion, the judges, by the time you get there, have looked at all of the medical records. So there's no surprise. There's no surprises. They know exactly what's going on, okay? So you don't have to worry about that. So they're reading records, though. They're just reading 56-year-old male, blah, blah, blah. They have no sense of your story. So what is important to do as part of your hearing is to describe, well, good morning, Amy, to describe how, or in terms of telling a story, hey, Sandy, how that affects you. I'll give you an example. If somebody were to say, I have back pain, that's kind of subjective. What's painful for you may not be painful for me. Who knows? But it doesn't really say much. But if you describe it like, I have pain in my back that feels like my grandmother's crochet needle is stabbing me in the back and causing me to have pain that goes down my leg. Well, everyone remembers what their grandmother's crochet needle looked like. It was about that big. It was some weird color, and you got an idea of something that's stabbing you in the back. And immediately there's a mental picture of, oh, that really must hurt. So in terms of how you want to describe things, you want to try and put it in terms of telling that kind of a story. I've had shoulder surgery. I can't open the refrigerator and take out a carton of milk. Thank you, Loretta. I can't take out a carton of milk because that would be too much weight and I can't extend my arm. Now, everybody in their world, in today's world, has opened the refrigerator to go grab something from there. And so if you describe it in such a way as telling that story, then everybody in their mind's eye will be able to see exactly what you're going through, rather than, well, yeah, I have pain when I lift things. Okay, I mean, that's good, but does that really tell us anything about how that injury or disability is affecting your ability to work? Now, the important then part of that, right? So that's how you describe the disabilities, but then it converts to, okay, my job was, as an example, my job was a senior corrections officer, or my job was a administrative assistant, where I was on the computer all day long, and I have carpal tunnel, and I have problems in my elbows, and I've had surgeries, and that would affect my ability to do . So the idea is to then take those stories and then be able to show how that affects, or how that would prevent from doing what you used to do. So there's a description. My job was this. This is how I did my job. And the reason that not only you want to describe what you did, but how you did it, is because at the hearing, Social Security sometimes brings along what's called a vocational rehabilitation expert. And that person is there to give the judge a description, a definition of what your prior jobs were, but then also to provide an opinion as to whether, based on all of your disabilities, whether or not there's some other job out there that you could possibly perform. So when you're there and you describe your job as, I was hey, good morning, Brian, I was a foreman. Okay, well, that could mean that I was sitting at a desk doing estimates, or it could mean that I was in the trench too, because I'm a working foreman. So, or I'm a supervisor, where I'm either at a desk or I'm a working foreman. So not only do you describe what you did, but you also want to make sure that you're describing how you specifically did it. That then allows for this vocational person to define your job, how it's specifically done. And the way they do it, they say, okay, well, what's called the Dictionary of Occupational Titles, or the DOT, defines it this way, but as it was done by the claimant, it was this. That's the important part, how it was done. So, because then the focus becomes, okay, well, that's how the job was done. Those are the stories of the disability. Now, how does that prevent you from doing that particular job? There are certain questions that will always get asked at a Social Security hearing, either by way of the judge or certainly by way of us in our office. You will be asked, how do you spend a typical day? Okay. Now, you don't necessarily have to go minute by minute, but, I get up at 6 o'clock in the morning, but that's only because I was up at 3 and 4 because I don't sleep well. And then I get up at 5 and I might have a cup of coffee. I might read the paper. I might do but 9 o'clock, I'm taking my medication and I'm falling back to sleep at 10. And go through a typical day. And if there is no such thing as a typical day, that's a typical day. Each day is different. Each day, I don't know what I'm going to get. It's your life is like a box of chocolates. You don't know what you're going to get. So, but each day is different, and the pain affects me this way, and the medication affects me that way. And you talk about all these bits and pieces, because what you're doing is you're coloring in the painting. So how do I spend a typical day? Next, you will definitely get asked a question. Why, in your opinion, do you think that you can't go to work? What are the things that prevent you from doing anything in terms of jobs? Now, understand what Social Security is saying. This is a big point. Understand what Social Security is saying when they say you cannot work. Social Security is not saying, well, you can't do 2 hours on a Monday and 2 hours on a Thursday. And thanks, Loretta. And that's work. Now, what they're saying is, how do your disabilities prevent you from going to work 5 days a week, 8 hours a day, every single day? And that's what they call work. So Social Security defines work as what's called substantial gainful activity, SGA. And I think in 2019, it's up to, if you're making more than, I think, roughly about $1,300. I forget the exact number, but it was roughly around $1,300. If you make more than that per month, hey, Sherry, then you are working according to Social Security. So having a little gig or being a part-time, I don't know, greeter at Walmart, just to come up with a title, a thing, does not mean that you are working for purposes of Social Security disabilities. And that's not something you have to show. You don't have to demonstrate that you're laying in bed 24/7. So if you're asked, what do you do during a day? And you say nothing, well, that's not really true. Okay. I mean, unless you're a complete paraplegic, you're getting out of bed. You're making a cup of coffee. You're having a glass of juice. You're reading a paper. Or you're watching TV. So Bryce is good. So those are the things you are doing. So I always tell clients, look, it's okay if you take your grandchildren or grandchild to school in the mornings to help out, because that's, a half an hour one way and half an hour back, and it's a 2-block walk. Okay. But that's something that you do, and it's okay. And it's okay to talk about it. It doesn't mean you're not disabled. It just means you're trying to do something that will help you both mentally and potentially physically. So it's not about, over exaggerating. Like I said, be mindful that when you're at these hearings, be mindful. The judges have read the records. They know exactly what's going on. So there's no need to, go over the top. How do the medications affect you? Now, some medications you take, there's no impact whatsoever. But, of course, I have clients that are sitting on oxycodone and Oxycontin, and, I'm sure are at some point during the day like a zombie. And then talking about how, because I don't sleep at night because of the pain, and the pain wakes me up, and then by 2:00 in the afternoon, I need to lay down and rest because I'm basically a mental vegetable because I'm so spent. And the pain and all of those things, that has an impact, and it has a psychological impact. And if you're having those problems in advance, if you're having those problems in advance, then you want to make sure that you're talking to your doctor about that, and that your doctor then either refers you to a psychologist or counselor or something. Because again, just talking about it means that the judge really can't hold on to that unless there's a medical documentation that supports what it is that you're saying. Somebody just asked about FMLA, which is the Family Medical Leave Act, FMLA. So in this terms of Social Security process, when you're starting and you are disabled or you're unable to go back to work right away, if you are with the entity that has greater than 50 employees, and from the time of your disability going back one full year, you've worked more than 1,250 hours, then you'll qualify. Good morning, Rose. Drive safely. Then you will qualify for, or you're eligible to collect, or not collect, you're eligible for what's called FMLA. And what that is basically job protection. So what happens is the employer will assert the FMLA, or you can request those papers. And what it does is it gives you 12 weeks of job protection, whereby as long as you can provide the supportive medical documentation to suggest that you're disabled for that period of time, then the employer has to keep your job, or a job that's of the equivalent, available based or until you're able to return. There's no dollars for FMLA benefits. It's basically job protection. Now, because it's an initial 12 weeks, usually that is the equivalent of if you're with a big company, they might have a private short-term disability policy, or you may not, and you may be eligible for state temporary disability up front. Those are dollars, but the FMLA is in essence job protection. Now, the employer has to assert the FMLA and send you paperwork that says, here, we need you to fill this out. They can do that later and then try and argue that the earlier period is what the FMLA is covering. But usually it has to be from the time that they assert the FMLA, then that's when you have your 12 weeks. So I hope that answers your question. So, but that's usually something that happens early in the process because of just the nature of the timing of how much it is. And again, early on in the Social Security process, these other benefits are important. Short-term disability, state disability, and if the employer has a long-term disability policy, then that long-term disability policy is one that's going to require that you apply for the Social Security disability so that they can basically, they being the long-term disability insurance company, can get their money back, because there are written provisions that say if you get Social Security disability and you're collecting long-term disability, the long-term disability insurance company gets their money back because now you've been approved for Social Security disability. So there's an offset. So anyway, so that's sort of a deeper dive today, a little bit longer than normal in the Social Security disability world. I hope that this was helpful, and certainly if somebody that you know is going through this process, please share this. If they have questions, please feel free to have them contact me either at 609-771-8611, 609-771-8611, or sgaylord@gaylordpop.com, sgaylord@gaylordpop.com. I'm more than happy to answer any of those questions, and certainly would be willing to assist at the hearing level. So anyways, I want to thank everybody for joining me. Thank you for the questions and the comments, and I appreciate all of that very much. I wish everybody a great weekend. Thank you, Loretta. Also, I want to be letting everybody know that this coming Tuesday, July 16th, we will be down in Trenton. We are the sponsor for a buddy of mine, his organization, Brian Blakely, and that we will be helping feed the homeless. And there's by the homeless shelter in downtown Trenton, there's a dinner and a movie. It's right past right past South Clinton. So I just want to have everybody, if you're around, if you're available, come on down. But it's this Tuesday, July 16th. We will be down there helping Brian and his organization feed the homeless. So I'm looking forward to that. And certainly I want to say thank you to everybody for joining me and sharing. Please make sure that you do that. And if you have questions, you want to get in touch with me, or if you want more information, like I said, you can go to our website, www.gaylordpop.com, www.gaylordpop.com, or email me, sgaylord@gaylordpop.com, sgaylord@gaylordpop.com. I'm happy to answer all your questions. And certainly then we'll put them on next Saturday, 9 a.m., Saturday with Sam. I'm Sam Gaylord, managing partner at Gaylord Pop and disability litigator in the state of New Jersey, representing injured workers in the areas of workers' compensation, Social Security disability, and disability pension appeals. I wish everybody a great weekend, and I look forward to doing this again next Saturday, and I'll talk to you then.